topics and opinions expressed in the following show are solely those of the host and their guests and not those of W4CY Radio, its employees, or affiliates. We make no recommendations or endorsements for radio show programs, services, or products mentioned on air or on our web. No liability, explicit or implied, shall be extended to W4CY Radio or its employees or affiliates. Any questions or comments should be directed to those show hosts. Thank you for choosing W4CY Radio.
Welcome to the Ask the Expert Show on W4CY Radio and Talk4 TV, where we bring you educational information from experts on such topics as legal, health, financial, and home improvement. Now sit back and listen to our experts in community association law, estate planning law, tax relief, Medicare, public insurance adjusters, neuropathy treatment, business brokers, and personal injury law, along with many other topics. Now here's your host for the last 17 years, Steve O.
South Florida, welcome to another Ask the Expert show, where for the last 17 years, what am I going to do when it's 18 years? This has been the most incredible run, and I got to tell you, this is such a special show. We do the first Thursday of each month with Kay Bender Rimbaum. They have been with us longer than any other of our experts. I believe it's 15 years now. And it's still, I can't wait to share some information with our expert who's like, he could do this by himself. He doesn't even need me. Let me welcome from Kay Bender Rimbaum, senior partner attorney Robert Kay. Good afternoon.
Good afternoon, Steve. Hello, everybody.
You know, Robert, your show is so easy to do. It does help that we get about 50 emails in each month, but now with TikTok, and I wanted to share this with you, what's so amazing, our show has just gone on the air, and maybe to some people it's not a big deal, but I'm looking at we're already over 1,000 likes. And we haven't even started yet. And I'm like
you.
No, it's not me. It's you. And I got to tell everybody, the last Thursday of the month, same time, 5 p.m. Eastern time, and the last Tuesday of the month, we do our Tampa and our Orlando show. I got to hate that we've been doing this for so long. People know you so well, but now with TikTok, I really have to ask you, tell people about Kay Bender Rimbaum.
Well, Kay Bender Rimbaum is a firm that specializes in the field of community association representation, condominium association, homeowner association, some cooperatives primarily. We provide all legal services on a day-to-day basis that an association may need. Be it review of the governing documents, provide a legal opinion as to rights and responsibilities of the association and the owners, dealing with covenant violations, dealing with unpaid assessment collection, dealing with contract negotiation, construction defect pursuit, any kind of litigation situation the association finds itself in, dealing with municipalities, code enforcement issues. Anything an association is going to deal with on a day-to-day basis is the legal things that the law firm will do. We provide these services continuously since 1992 and do so now out of our 4 offices in Pompano Beach, Palm Beach Gardens, Orlando, and Tampa. But with the way things are on the internet today, we pretty much cover the whole state.
So this is our first question from TikTok. Hey, I saw your show. I'm very curious. What is the difference between a community association law firm and a management company?
Well, they do completely different things. A management company assists with the operation and the business aspect of running the association on a day-to-day basis. They deal with contractors, they deal with the board, they follow the instruction of the board, they make recommendations to the board on policy for the board to consider whether it chooses to adopt it. The law firm is separate and distinct and provides legal guidance on legal issues that the association may need from time to time. And the law firm doesn't get involved in business decisions and telling the board what to do or not to do. The law firm, if it's doing its job correctly, will be providing guidance as to the law and what are the ramifications to the board if it chooses to go one route or another route on any issue that it may be facing, and assisting in that type of an aspect.
Robert, I don't know if there's been articles that have come out lately, but all of a sudden we got inundated, and I just pulled one. This is from Richard and Boca. Why doesn't the DBPR investigate HOAs? We got so many questions, people saying, how come there's not statewide guidelines for HOAs?
Well, that is an issue of what the legislation provides for the types of ownership that exist in Florida. For condominiums in Chapter 718 of Florida statute, that's where the Division of Condominiums was created, which is within the Department of Business and Professional Regulation, the DBPR. And it addresses issues for condominiums and has been in place for over 45, 50 years. For homeowners association, the statute involved is Chapter 720, and there is no involvement of the Division of Condominiums in homeowner association provided for in the statute, with the exception of election issues. Election issues has been brought into the purview of the Division of Condominiums. Since it handles them for condominiums, it has been authorized to assist in election disputes in homeowner associations as well through the arbitration section of the Division of Condominiums. There is no Division of Homeowners Association created by Florida legislature, and that's why there is no involvement of the DBPR in doing investigations.
Okay. Here's what, as long as we've been doing the show, here's, I guess I've never heard this before. This is Kelly and Delray. What is Robert's Rule of Order? A friend of mine brought it up, and I didn't want to seem dumb to ask what it was.
Robert's Rules is an old book that creates rules of procedure for how meetings are to be run. And it tends to apply more in governmental settings. Somebody makes a motion, somebody seconds, when there's supposed to be discussion, and how voting is handled within the meeting. And it's been out for a long time. And many communities' documents provide that meetings shall be handled under Robert's Rules of Order when practicable. That's usually what we see in the bylaws. And it's really guidance more than anything. It's not law. It's just a guide on how you should properly run a meeting, at least under those rules. Now, do you have to follow Robert's Rules of Order? No. The reason to do so is so your meetings go in an orderly fashion and they don't get chaotic and out of control, that people speak when they're supposed to, and they follow that orderly progression of how the meeting should be handled. And that's a good recommendation.
This is from our chat line. The board and ARB want to approve a fence taller than what is expressed in the covenants and won't accept my advice or seek legal advice. How do I protect myself as the management company?
Well, as a management company, you should put your advice in writing to the association. And if they choose not to follow it, then that's all you can do. You've done your job by providing your advice as to what they should be doing. And if the board chooses to go in a different direction, then any liability falls to the board, not to the manager. And you've got it documented.
Okay. This must be a community that has trails This is from Larry in West Palm Beach. There is a potential for some of our members to be attacked by wildlife when walking on our trails. Do we need to put up a sign to protect ourselves?
This is a question that one best posed to the association insurance provider. If the association in general terms is aware of a situation that may be dangerous to the community, that creates an obligation to provide notice of that situation at the very least, to minimize the exposure the association may have to a claim that it knew of something and should have warned the community about it. So putting up signs is a method of reducing the potential liability of the association, but it will not eliminate it completely, because people will still, if there's a situation that occurs and they want to bring legal action, they will include the association in that legal action. So yes, it's a good idea to put up some form of notice, but I suggest that you have a consultation with your insurance provider so they can do an evaluation and give you direction to make sure that you're best protected under your insurance policy for any incident that may occur.
Here's a question from TikTok. I just found your show today. I'm so glad there's finally a show like this out there. My question is, what do boards have against metal roofs?
Well, I don't know that I can offer a blanket opinion as to what boards may have against it, but a lot of times when we see the boards are not looking to get involved in metal roofs, it's more from an aesthetic perspective than it is from the utility. There may be a differential in the cost factor to the association in putting in a metal roof versus the more conventional roof that currently exists. There may be a requirement in a condominium to get a vote of the owners for a material alteration when you're going from a more conventional roof to a metal roof, although they're both roofs, because of the material change in the type and the longevity and the cost, that likely would fall as a material alteration that may require a vote depending on what the documents provide in that situation. I think that the metal roofing industry has evolved significantly over the years, and the product that they put out doesn't look a whole lot different than what other more conventional roofs are, and it's something that should be considered if it's within a reasonable price differential than what the board is considering, and falls within the budget that the association is working with.
Jackson and Lantana. We are a condo. We are a board that is very involved. You would be pleased how well we work with our law firm. We hope that's K. Bender Rimbaum. We are a new board member. Can you explain the Sunshine Law? We are a 5-member board.
The Condominium Act provides that whenever a quorum of the board gathers to conduct association business, that's the key phrase, conduct association business, then there has to be advance notice of that, and there has to be allowing owners to attend and participate in the meeting. The phrase conducting association business has never been defined by the statute, nor has it been defined by any case law that I'm aware of through the years. So the rule of thumb that is most commonly applied is that when the board is making decisions, taking action on behalf of the association, that is what is conducting association business from the perspective of whether you have to provide notice and allow owners to attend and participate. When the board is fact gathering or just having a conversation about the possibilities, but not making decisions, that would not necessarily be a meeting of the board under the definition that the statute provides. There is some objective basis to conclude that, in that the statute was amended some time ago to allow board members to have conversations by email about issues that the board is considering. And those are not considered meetings of the board. They just cannot vote by email. So they have to vote at a meeting that they're physically at or virtually at that's open to the membership. That can be analogized to the conclusion that you can have conversations and not be violating the quote unquote sunshine law, which really sunshine applies to government meetings, not private community meetings, but it is a common term that gets used. It's not as quite the same as what the governments are required to do. So that's in essence what they're dealing with. Quite often, they also need to keep in mind that sometimes the board members are also the officers of the association, and those are two different functions. Consider it like different hats that you wear. If you wear your director hat, you're doing one function for the association. If you're wearing your officer hat, you're doing a different function. There is no requirement of when the officers meet and they're doing their officer tasks for the association, that constitutes a meeting of the board that needs to be noticed and owners have to participate in. And oftentimes owners get confused because they see the board members who are also officers in the office doing their thing as officers and think they're having private meetings. Now, could there be some crossover? Sure. But in the strict technical situation, they're two different things, and you kind of have to look at the facts and circumstances of each particular situation before you reach a final conclusion.
Well, for those of you who are writing in about the schedule for the month of August, we're going to be going there in just a minute. I want to get this last question in before we go over your schedule for the month of August. This is from Christine in our chat line. In a condo, the water line from the shutoff valve to the building, who is responsible for the repair if it should break?
Well, that's really going to be document specific to that particular condominium. So you'd have to look at the documents to see what the boundaries are of the unit versus the common elements and what the maintenance responsibilities are expressly stated within the documents. The statute doesn't provide for that answer. So you have to look at your governing documents, and they're not all the same. So to make a determination one way or the other, you will have to do that analysis before you can reach a conclusion.
Okay, let's go to the schedule for August with all your classes coming up. And most
right. Well, and from your perspective, it's a light month.
Okay.
We have on August the 11th at noon on Zoom, HOA record keeping and records access. There'll be credit for managers and for HOA board members. Emily Gannon from the Pompano office will be presenting, and it's hosted by the CAI Southeast Florida chapter. On August the 12th at 11 a.m. on Zoom, screening process, developing procedures and training your committee. There's credit for managers on this presentation. Chris Posner from our Pompano office will be presenting, and that's going to be hosted by Association Community Education. On August the 17th at 2 p.m. on Zoom, Navigating the Federal Fair Housing Act, FFHA, Assistance Animals or Pet. There will be credit for managers on this one and for HOA board members, and Alan Schwartzide of our Orlando office will be presenting on that. People may be aware that HUD has recently come out with a statement that emotional support animals is not something that they're going to be pursuing on a federal level, which complicates the fair housing aspect, because that's what we're talking about with assistance animals. But there is still some state law provisions that do incorporate that concept. So that's still an issue that is open for consideration to the board. So that's something you may want to consider attending to hear the most recent views on that topic. August 21 at 10 a.m. on Zoom. HOA is a board member certification course. Credit for manager and certification for new HOA board members as required by statute. Kirsten Hens of our Tampa office will be presenting, and it's hosted by Empire Management Group. That's all we have in August. But before our next show on September 2nd, we have a live event at the Tamarack City Center. We have an Ask the Attorneys, an open forum Q&A discussion on community association law and topics, one of your favorite kind of ones that we've had in the past, Steve. Emily Gannon from our Pompano office will be there to answer questions submitted by the participants, and they'll be talking about follow-up questions and having that lively discussion that tends to come when people start adding to each other's questions. And then on September 3rd at noon on Zoom, we have a legal update 2026, which is basically the changes in the laws from 2025. Managers will need this before the September 30th CAM license renewal deadline. And Alan Schwartzide from the Tampa office will be presenting, hosted by Campbell Property Management. That's what's upcoming. If you're interested in any of these courses, go to our website, kbrlegal.com, click on the calendar, click on the event you're interested in, and enter your registration information so you get the Zoom credentials for the Zoom presentations. It would be good to RSVP to the Tamarack City Center on September 2nd, so we would have enough information for everybody who comes.
I wish you could see all the people who are thanking us for your show. We're going to go to a break right now. When we come back, we've got more of your questions. We'll be right back.
K. Bender Rembaum is a full-service community association law firm dedicated to the representation of community associations throughout Florida. On kbrlegal.com, you can learn more about their offices in Pompano Beach, Palm Beach Gardens, Orlando, Tampa, as well as throughout Miami-Dade by appointment. Several K. Bender Rembaum attorneys are board-certified specialists in condominium and plan development law and assist clients with all matters of community association legal issues while keeping them up to date on new developments that affect their associations. K. Bender Rembaum is also a well-known provider of free legal education for managers and board members. Contact K. Bender Rembaum today by calling 800-974-0680. That's 800-974-0680 to reach any of their locations. You can also visit them online at kbrlegal.com or write to them at info@kbrlegal.com.
And we are back with the Ask the Expert show on W4CY Radio and Talk4 TV with your host, Steve-O, and his expert guests.
And we are back. This is the Ask the Experts TV show. Hey, I got to just share this with Robert. I told him right before the show started, we had almost 1,000 likes. We are now at 4,163 likes. And
Thank you for liking us.
Yes. Well, I told you, you and Robert you and Michael used to do the show together. Seems so long ago. But
it does.
You have developed. I mean, people love the way you explain things. You don't talk over their head, and people just really appreciate you. They appreciate the show and the format, and I'm so glad because this is such an important topic. And I'm just looking at just TikTok alone, and people are staying on for the entire show, which is usually unheard of. People will do it for about 10, 15 minutes, and not with your show, they don't. But let's go to everybody's questions. I'm going to go to Rex in Fort Lauderdale. And I love this, Robert, because we got them pretty much trained to tell us if they're a condo or an HOA.
It's necessary. They're different.
Yes. So this is a condo. He says, I'm on the board of directors, and we didn't believe in committees. Now we have committees, and we've created a monster. Everyone's calling themselves a committee. Is there a way to structure this so all these committees are just popping up? How does the board keep from being held liable?
So for committees, you want to refer to your governing documents, primarily your bylaws, to see whether there are specific committees that are provided for in the documents, which usually are appointed by the board and no other way. The board, whether their documents provide for that specificity or not, can adopt a policy that indicates that the only valid committees of the association are those that are appointed by the board and fall within the oversight of the board, and anyone else who's calling themselves a committee is not an official committee of the association, and they're just doing it on their own. And making that a formal written announcement to the community, and then the board appoint what committees it wishes to have, or if it doesn't wish to have any, it can certainly make that decision as well, unless the bylaws require some.
Sean and Boca, HOA, legislation for HOAs, they have created statutes for HOA boards to be restrictive in regards to the fining process, like parking violations. We fine residents, but then they move their car when they receive the parking violations. What are we to do?
Well, it depends on what the violation is. If is the car the violation, or where it's parked the violation, or the time that it's there the violation, you need to get with the attorney for the association to establish exactly what it is that you want to accomplish. So you may need to revise your documents or adopt a different rule that will provide you a little bit more enforceability of what you're trying to accomplish. Fining is a method of enforcement that's optional. It's not mandatory, and has a strict procedure under the statutes that has to be followed in order to be valid. Which requires a notice to the owners of a specific violation and the fine that's being imposed upon them, and an opportunity for a hearing before a committee that will evaluate whether or not the fine should or should not be formally imposed against that particular owner. The fine can be up to $100 per incident, and each day can be a separate fine up to a maximum of $1,000, unless your documents provide for something higher. And in an HOA, if the documents provide for a collection of fines through the assessment process, it generally has to be over $1,000 on a particular violation. Then it's possible to pursue them that way. Otherwise, fines are not lienable, collectible as assessments, which make them much more difficult to enforce. But if somebody's doing, and it's usually a fine is better for a violation that's short in term, because if you go to court about a violation that occurred before but isn't happening at the moment, the court's not going to be interested in that because there's no current violation happening. So that's one of the reasons that people use the fining process. But you probably need to get with the association council and address the specific issue in a way that's going to be more effective for you.
Let's go to our chat line. She said, so are you saying that if the officers gather to discuss an issue, they don't have to post the meeting in advance?
Well, officers don't necessarily gather to discuss an issue. They're doing their officer function. Like the treasurer is doing something with the books and record or the accounting records of the association. The secretary is overseeing the other books and records. The president is dealing with the day-to-day issues that come up. If they're talking about policies that the board has adopted, then yes, that's not a meeting that requires a notice and an opportunity for owners to participate. So really, it's not a method for them to take action and conduct business under the guise of being officers. It has to be legitimate that they're doing their officer functions versus making decisions and adopting resolutions.
This is also, God, we got a lot of board members watching today. The only remaining bulletin board, others have been removed, is in a corner of the clubhouse, which is rarely seen. Notices are also posted on the website. Can this be considered duly noticed?
Well, duly noticed is posting it in a conspicuous place that the board has identified as where notices will be posted within the community. And if there's a bulletin board that exists, even though it might not be front and center, but everybody knows about it, and the board says this is where we'll be posting things, and they are posting things on a website, which is also available to everybody to see, it'd probably be a good idea if they also do an email blast from time to time when they're posting something that, hey, we posted something on the website, but owners are really the ones responsible to be monitoring the website for those notices if that's the established location for posting of notices.
Chris in Delray Beach, what can be done when an owner failed to disclose their 5 children under the age of 18 to get the approval of the association, and the association finds out after the fact?
Well, I guess we need to know what the specific issue is. If this is housing for older persons where children are legally excluded under the age of 18, then your remedies are one thing. If it's a limitation on the number of occupants that can be within a unit as permanent residents, then your opportunities are something different and a little more limited depending on where the community is located. Some counties have, such as Broward has an ordinance that says children under 10 are considered a half a person for the purpose of counting occupants within a unit for unit limitations, occupancy limitations. The other concern is that if a limitation has what's referred to as a disparate effect on families with children under the age of 18, it can be found to be discriminatory under the fair housing laws, even though it violates the number of people that are allowed to permanently reside based on the number of bedrooms. So those are issues that need to be determined before you can know. If it's housing for older persons community, then that owner would be subject to legal action to compel the removal of the children, because there is no legal way for the children to permanently reside in the community under those circumstances. So this questioner needs to get with that association council and finish off the information needed in order to determine what the proper course of action is going to be.
Cheryl in Miami, I currently live in a community with 5 HOAs and a recreation HOA. Which is the master?
Well, there may not be a master in the terms of a hierarchy of one up here and then 2 below it or 3 below it and then another one below that. They do different functions depending on the documents of the community. Like a recreation association could be overseeing certain common properties that are available to all of the communities, like a clubhouse or tennis courts or swimming pool, things of that nature. That's not a quote unquote master association because they're limited to what their documents give them the authority to oversee. But some people consider a master association, which is inclusive of other communities within the same larger community, and that makes it seem like a master because their covenants apply to everybody. But it really depends on what each specific set of documents identifies as the function of that particular association.
She has a follow-up question wanting to know, is it a conflict of interest for an attorney to represent both our HOA and the Master Association? There are 13 other communities in the Master with our own attorney.
Well, it's a potential conflict if and only if there is a conflict between the master and the sub-association. And in that instance, the attorney will typically not represent either on that disputed issue, and they'll each have to find alternative counsel to deal with that. For instance, let's say you have a situation when both the master and the sub are pursuing collections against an individual owner, and they both have filed liens. One of them is superior to the other and could wipe out the other by pursuing collections through the lien and foreclosure process. That's a potential conflict that could require the attorney to step out of representing both parties. And generally, the attorney should be working with them to resolve that conflict and make sure that it isn't an impediment to providing that representation.
Let's go. Can a condo board fight its total recall using association funds, forcing the community to raise its own funds to fight for the recall?
Well, the short answer is yes. If the board has a legitimate basis to challenge a recall, a legitimate legal basis, then the association funds are all it has at its disposal to make that claim that it's improperly done and to defend its position. And as the attorney for the association, our function would be to assist in making that determination whether or not there's a legitimate legal basis to challenge the recall or not. Until the recalling owners have succeeded in their recall, they're individuals paying their own way.
I got to ask you a favor. We are getting so many people who miss the schedule. Would you mind going over your schedule again?
Not at all. On August 11th at 12 noon on Zoom, HOA record keeping and records access. Emily Gannon from the Pompano office. It's hosted by CAI Southeast Florida chapter. There will be a credit for managers and for HOA board members. August 12th, 11 a.m. on Zoom, screening process, developing procedures and training your committee. Christopher Posner from the Pompano office will be presenting. It's hosted by Association Community Education, and there is education credits for managers. August 17th at 2 p.m. on Zoom, navigating the Federal Fair Housing Act, assistance animal or pet. There's education credits for managers and for HOA board members on this one. Alan Schwartzide of our Orlando office will be presenting. And then on August 21, we're presenting an HOA board member certification for new board members at 10 a.m. on Zoom. There's education credits for managers and certification for new board members for HOAs. Kirsten Hens will be presenting from our Tampa office, and it's hosted by Empire Management Group. On September 2nd, there's a live event at 5:30 p.m. at the Tamarack City Center, an Ask the Attorneys with Emily Gannon from our Pompano office. It's an open forum of Q&A discussion on community association law and topics, which are the questions that are posed by the participants present. Whatever questions they bring are what will be discussed. Then on September 2nd, well, make that September 3rd, at 12 noon on Zoom, 2026 legal update, which are changes in the laws from 2025. Education credits for managers. They'll need this before the September 30 CAM license renewal deadline. Alan Schwartzide of our Orlando office will be presenting. It's hosted by Campbell Property Management. All of these items can be found on our website at kbrlegal.com. Click on the calendar, and then it'll identify all these upcoming events. Click on what event you're interested in and fill out whatever's needed to register and get the information on how you can access the program.
Well, I got to tell you, if we hadn't had so many people requesting, we probably wouldn't have gotten to it, but I'm glad we could. Let me go to Ron in Fort Lauderdale. He said, we have 12 deeded boat slips. 3 owners gave back 3 boat slips to the Condo Association. Can the association sell those slips to the owners?
Well, with the boat slips, you're going to have to look at your specific documents to see how they're handled, if they're handled, and whether or not the association has the ability to sell them or lease them or assign them, or just what the limitations are on how they can be used. Sometimes the documents, particularly in some of the older communities, don't really fully address the topic, and it might require some assistance from association counsel to get to the bottom of what your limitations and rights are with respect to them. Sometimes it's not clearly identified as even being part of the condominium, and it might fall outside the boundaries of the condominium, which can tend to complicate those things. So this is an issue that you will need to have your association attorney dealing with your governing documents to get a complete determination for you.
Nelson in Coral Springs, in the election meeting, can they vote on an amendment to take over the fences from owners if it is not on the agenda? And would that fall under new business or old without listing it on agenda?
Well, if we're doing an amendment to the governing documents, it has to be properly noticed, and it has to be sent out to all the owners in advance of the meeting with a specific amendment language that's being considered as part of the notice for the meeting, and it does have to be part of the agenda. Just taking a vote at a meeting without following those notice procedures would be a defective adoption of the amendment, subject to likely successful legal challenge.
Sony in Delray Beach, if a new director is appointed, is it not active until formally accepted and in the minutes?
Depending on how the new director is appointed, quite often it happens at a meeting. I generally like to see the individual accept the position before we consider it to be official. I don't feel that it's makes a difference when the meeting minutes are completed. The effective time would be at the point that the individual accepts the appointment to become a director.
Okay, let's go to Sylvia and Pompano. What happens to owners who are forced to replace windows and doors but can't afford it and can't sell quickly either?
Well, those owners can be subject to the enforcement authority of the association, which can result in litigation against them by the association to ask the court to compel them to do what's required under the governing documents. I'm going to have to assume from the question that the governing documents contain the obligation for the owner to replace the windows with hurricane protection. And that usually comes about by an amendment that the owners have voted on to change their documents to make that a requirement. The fact that the owners may be having problems with the ability to pay for that revision is something that the owners need to address with the board and try and work out some accommodation. Otherwise, the owners are going to have to find a way to either get it done, or they may find themselves involved in what can be even more costly litigation.
Mary in Boca Raton said, did I hear on one of your shows correctly that placing an outdoor camera to the exterior of my home in an HOA could be considered a material alteration violation?
I'm going to have to say no, you did not hear correctly, because material alteration is a condominium concept, not a HOA concept. So with respect to making alterations outside your home, you would need to consult in your governing document, your declaration of covenants, to see whether there is any limitations. Sometimes there is a referral to an architectural review committee that can create guidelines. So you'd need to review those guidelines to see if there's any limitation on the ability to place that on the exterior of your home. But from the perspective of a material alteration that requires a vote of the owners, that would not apply to this scenario.
I want to tell everybody that if you've missed part of the show today, we're going to be replaying the show tomorrow at 2:00 Eastern time. Just a little favor that we can extend to K. Bender Rimbaum. Robert, tell people how they can reach your office.
You can reach us by calling 800-974-0680. You can write to us at info@kbrlegal.com. Or you can go to kbrlegal.com, and on the first page of the website, there's a request for contact form that you click on and fill out, and then someone will reach back to you within the next day or so.
You've got the greatest website. There's so much great information on there.
Yeah, we appreciate that. Thank you.
So Robert's with us again the first Thursday of the month at 5:00 Eastern time. And I've been watching this because I wanted to give the final results to Robert. We had 6,173 likes. Not bad.
Nice.
Not bad. That's just on TikTok. Anyway, Robert, thank you so much. Be well, my friend.
You as well. Enjoy your new vision.
Yes, thank you. Hey, that's attorney Robert K. Bender Rimbaum. They've been with us for 15 years. Anyway, they also do a show on the last Thursday and Tuesday at 5 p.m. This is going to do it for us today. We'll be back again with you as a replay tomorrow at 2:00 Eastern time. We'll be replaying the K. Bender Rimbaum show. Hey, everybody, have a wonderful weekend. We'll see you on Monday.
Thanks for tuning in today to the Ask the Expert show on W4CY Radio and Talk4 TV. Tune in next week and every week to hear more from our experts on personal injury, insurance, air condition repairs, estate planning, Medicare, and many other topics in the areas of legal, health, financial, and home improvement. See you next week.